21 of the first list for withdrawal of the
Item 21.
शनिवार को मेंशन किया था जो आज लिस्ट हुआ था उसको खाली ऐसे कर रहे हैं कि उसको जो कल के लिए रख दिया जाता है।
SC number 579 of 2016.
yes, fine.
The learned counsel for the applicant seeks permission to withdraw this certain appeal by filing IA number
IA नंबर 13465
13465 of 2020. Considering the submissions, considering the prayer for this withdrawal, this appeal is dismissed as withdrawn.
Your Lordship, I appear for the respondent DCCN.
साइन कर दे उनको
You have to put your signature.
साइन कर
Your Lordship, I appear for respondent BCCN.
Do you have any objection?
No.
The learned counsel for the respondent DCCN has no objection for the prayer.
एक है वही आइटम नंबर 22 हम कल के रखने के लिए बोल रहे हैं सैटरडे को मेंशन किए थे आज रखे थे हम कल मेरा किस्मत है जो नहीं रहा
हमारा भी किस्मत हम नहीं कर पाएंगे लगभग नहीं पॉसिबल है लास्ट वर्किंग डे छुट्टी के बाद करिएगा सर
एक्सटेंशन था जो नीचे को प्रेशर डाल रहा था इसलिए
कोई प्रेशर नहीं है सब छुट्टी में नया साल में
This case item 33, second appeal 191 of 2025.
Your Lordship, the matter is from court number 16 and Your Lordship. The matter is listed as partner for today, Your Lordship. It's a number where edition just for edition to fix it for 5th January, Your Lordship. The Arbitral Council is coming from outside for us. It's the partner matter in court number 16.
there is a counsel for the other side
Right.
part cases were you see the problem is on the opening we do not know what is the constitution of the bench then how do we fix a matter like this it is not possible you ask your counsel to come on some other day on opening you mention it and then only you can
Okay.
we are not going to fix any dates like this
One IA with outside the list.
outside the list
इधर दे
क्या करना आपको छुट्टी के बाद
एक्सक्यूटिंग कोर्ट 5 तारीख का डेट रखा है इसे डिलीवरी ऑफ
कौन
पोर्शन
से ऑर्डर से रखा है 5 तारीख
ये फाइनल ऑर्डर फाइनल डिग्री के अगेंस्ट में एक्सक्यूशन है
कौन सा ऑर्डर आपने चैलेंज किया है
एक्सक्यूटिंग कोर्ट का नीचे
सेकंड
सेकंड अपील इज पेंडिंग
कोर्ट का कौन सा डेट का ऑर्डर है
डेट का ऑर्डर ये 26/12/2024 25
किसने लिखा है
वो
26/12
मजिस्ट्रेट हाँ मजिस्ट्रेट अपॉइंट हो चुकी है
26/12/2025 का आ गया क्या 2025 26/12
26/25
26/12/2025 आ गया क्या 26 तारीख हो गया अभी
सॉरी
कुछ भी जो
the next date is fixed in the court 2026
आराम से
हिंदी अंग्रेजी बंगला कुछ में भी कुछ बोलिए तो सही आपसे ये पूछ रहे हैं कि जो ऑर्डर में जिस डेट में एग्जीक्यूटिव के कोर्ट ने ऑर्डर किया है उस
वो
ऑर्डर का डेट कब का 18 ऑफ
12 December 2025
अभी इतना शॉर्ट में क्या होगा
मैं ऑलरेडी सेकंड अपील जो है वो इसमें है और एक उसका
सेकंड अपील एडमिट हो चुका है
हाँ ये हुए ऐसे आप कॉल फॉर हुआ था
एडमिट होकर कि बिना एडमिट
एडमिशन के पॉइंट पे तो
अब छुट्टी बात करिएगा कुछ नहीं होने वाला आप बोलिएगा कोर्ट में
इसको अलाउ कम से भी
क्या करें हम अलाउ करके छुट्टी के बाद का कोई डेट नहीं फिक्स कर सकते हैं क्योंकि छुट्टी के बाद का बोर्ड का नहीं पता ना
नहीं हम कल के लिए मेंशन
कल के लिए अच्छा लिस्ट कर दीजिए टेकअप नहीं हो पाएगा लिस्ट हम करा
One serial number 34 today's
लेकिन
list.
टेकअप होने का लिस्ट ज्यादा मत रखिएगा वहाँ लिस्ट दिखाइएगा केस लिस्टेड
Today's list marked serial number 34 marked second appeal arising out of eviction suit. London Court executing had fixed on 3rd of January marked for issuing delivery of writ of appeal. It is an admitted appeal and earlier stay order was also there, but the stay order was of 2012. Now the London executing court is not saying
सीरियल नंबर कौन सा
34 marked.
आपके अदर साइड तैयार
हाँ,
है?
ये list है।
हमने आई रेडी भी थी मैडम 96 का एविक्शन सूट है
This is
मैडम
BBC Act.
एक बीबीसी एक्ट मैडम एविक्शन सूट
आप
है
कौन है? Tenant.
टेनेंट है
हाँ, tenant है।
दोनों
हमारे-
कोर्ट से हारे
हमारे
किसी
पास
भी
में
कोई substantial question of law तो
तो
बना होगा।
बना है वो हम नहीं कर रहे
क्या
हैं
बना?
लेकिन अभी नीचे सब कोर्ट बंद है दो एग्जिबिट है एक एग्जिबिट बी और एक सी है इनका उस पे बना है एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ छुट्टी के अभी तो सिविल कोर्ट भी सब बंद है अभी स्टे लेकर के
3 जनवरी
बार बार यही हो रहा है मैलट जब वहाँ
3
प्रोसीड
जनवरी
होता है तो ये यहाँ कर लेते हैं 96 का एविक्शन सूट है
3 जनवरी को रखेंगे
96
लर्नेड एग्जीक्यूटिव।
हाँ वो तो रख दीजिए ओपनिंग डे में रख दीजिए कोई दिक्कत नहीं है वो तो
इसको 5 तारीख को रखना।
हाँ
इसको
कुछ
टॉप ऑफ
नहीं
द
हुआ है।
केस रख दिया जाए।
हाँ हाँ तो फर्स्ट एज ए फर्स्ट केस रख दिया जाए हम भी
इसको otherwise ready है?
अदरवाइज रेडी है मैडम
तो final disposal में
हाँ
रखना।
हाँ माइनर एग्जाम में एकदम माइनर
Serial number 34. The learned counsel for the parties are present. The counsel for the applicant is praying for stay of execution proceedings. The learned counsel for the respondents has submitted that the case is otherwise ready for final disposal and the matter arises out of
eviction suit
eviction
of
arising out of
default in making payment of rent of the year 1996
the case is relating to eviction suit
मैडम
arising out of default in payment of rent. The suit is of the year 1996. The tenant is the appellant before this court has lost in court appeals. With the consent of the learned counsel for the parties, both will stay for final disposal until.
मैडम
टिल देन और
क्या कुछ
3 जनवरी को मुझे ऑर्डर कर देंगे तो
नहीं कुछ नहीं हो रहा है सब
हमारी
चीज
application
सारा
फाइल
सिविल
किए।
कोर्ट बंद है
5 जनवरी तक
सारा
clear
सिविल
किया
नहीं
है,
नहीं
protect
फिर
किया।
उसके बाद फिर रुक जाएगा नहीं
First
नहीं
case है,
नहीं
first
माय लॉर्ड
case।
आई विल अपोज
5 तारीख
विद
को
फोल्डेड
यहाँ भी
हैंड
रहेगा हम
हाँ बस
एकदम पक्का कर आप ये नोट्स बनाइए
हाँ ठीक
ठीक है नोट्स बनाइए ठीक The learned counsel for the parties are directed to prepare short notes of arguments and also furnish copies of the judgment which is secret line.
मैडम
ठीक है
जी
और बताइए अभी आपका और मेंशन है
मेंशन नहीं हुआ एडिशनल सब्सटेंशियल क्वेश्चन
किसमें
इसी में
तो
इसी मैटर में अच्छा अभी एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ भी बनाना है हम ऐसे थोड़ी लेंगे आप जानिए आपको
उस दिन तक
उस दिन करेंगे फिर उस दिन टाइम लेंगे
इसीलिए स्टे हम अपोज किए मैडम इसीलिए इसीलिए
आपका आइए है आपके हाथ में
आइए भी है आइए फाइल की है आइए हाथ में आइए फाइल
आइए फॉर एडिशनल सब्सटेंशियल
No.
फिर आपके हाथ में क्या आप करना है
एडिशनल सब्सटेंशियल क्वेश्चन
आपको वैस करना है
हां सर इसीलिए तो
ये मैटर में इसमें हजू ऐसा है कि
नहीं,
एक्स
समझ
पार्टी
खुल
डिग्री
जो है मेरा सर नुकसान हो गया
I'm saying ex party degree is in my favor. And my lord, they to
आप कौन है
circum.
रिस्पोंडेंट
नहीं
No, I'm
हम
the tenant.
ये टेनेंट
I'm the
है
appellant.
सर लोग दोनों हैं एक साथ
अच्छा अच्छा
और वो कह रहे हैं कि एक्स पार्टी डिग्री हो गया है जिसमें ये होल्ड हो गया कि सूट का प्रॉपर्टी का शेड्यूल अलग है
जस्ट
Ex party, there is an ex party degree which is in my favor. And my lord, to circumvent that ex party degree, they filed an eviction suit. And my lord, the eviction suit, the suit was decreed, appeal has also been done. There are two substantial questions of law has already been framed, but the question of law, my lord, which I want to advert, that is here.
तो आइए फाइल कीजिएगा उसके बाद उसको नहीं आइए फाइल कीजिएगा प्रॉपर तो वही ना है सर
आइए
प्रॉपर तो वही है
हम
कि
तो आज ही बहस
सब-
करने के लिए ready
नहीं
हैं।
तो रेडी है तो 5 को रहेगा उसके
इस पर इसको खाली रिकॉर्ड पर ले लीजिए
नहीं,
affidavit हम
बिना
कर
आइए
ऐसे-
के हम इसको ऐसे
बिना आइए के नहीं
नहीं
होना
Affidavit ले
चाहिए।
देते हैं।
हाँ
Affidavit
वही तो कर
वो हम नहीं चाहते बिना आइए के नहीं हो सकता है क्योंकि बिना अदर साइड को सुने नहीं हो
नहीं हो
सकता
वो तो है। इसीलिए तो हम हुजूर आज
और
अपना-
उसके बाद इस आइए का दो पॉसिबिलिटी जैसे ही हम इसको अलाउ करेंगे तो आपको बोलेंगे टाइम दीजिए
जी।
पॉइंट नंबर 1
इसीलिए तो इसीलिए तो आज ही दे रहे थे इनको।
दिस इज पॉइंट नंबर 1 सेकंड पॉइंट इज जैसे ही वो हम रिजेक्ट करेंगे आप बोलेंगे अभी हमको टाइम दीजिए इसको चैलेंज करने के लिए
कि हम इसमें इसलिए तो हमारे
और क्या?
इसमें बोनाफाइड में हम इनको अभी दे रहे हैं कि दिस इज
नहीं 5 तारीख को ले लेंगे ना हम सब
तो
हम
5
सब देख
तारीख को
लेंगे
ये लेने की जरूरत क्या है अगर मान लीजिए
नहीं,
ये पॉइंट
पाँच-
चाहते हैं
हाँ 5 तारीख को ले लेंगे आएंगे
और इस पे ऑलरेडी स्टे था ऐसा नहीं है कि स्टे दो बार 3 बार एक्सटेंशन हुआ
यहाँ भी आप इतना लड़ाई करना मत
ठीक
अब तो
है
कम से कम इतना ठंडा में तो 6
कुछ नहीं होगा सब सिविल कोर्ट बंद है तो
अब 3
कैसे
तारीख का
रहेगा?
3 तारीख का इसमें डिग्री के लिए रखेंगे
नहीं,
आप एक बात बताइए 2010 का सेकंड अपील अभी आप लोग को होश आ रहा है कि एक एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ में फाइल
एक बार सर ट्रेन कराए हैं, दोबारा कराए जो 14 में, उस समय तक फिट नहीं था, 11 में एडमिट हुआ मैं लॉर्ड, फिर 14 में जब टेकअप होने लग गया, फिर नहीं हम बियॉन्ड रिकॉर्ड नहीं बोलेंगे सर,
Beyond record
खाली बस
is-
उसका नंबर चेंज
हुआ
तो नंबर तो आने दीजिए ना, 5 तारीख को हो जाएगा,
ये लेकिन
सब लोग मर गया है और
ये-
लैंडलॉर्ड
ये
बहस
point
होने
of-
दीजिए, बहस होने दीजिए,
ये पॉइंट ऑफ लॉ
बहस होने दीजिए बस।
देखिए लैंडलॉर्ड टेनेंट रिलेशनशिप का स्कोप बहुत
आप इसीलिए तो हम कह रहे हैं कि ये सुटी मेंटेनेबल नहीं है, दैट व्हाट इज द सब्सटेंशियल क्वेश्चन,
तो ठीक है, वो आप कीजिएगा,
That is
5
what
तारीख
is
को रहेगा, बहस कीजिएगा, डीपीओ
रेंट का प्रूफ आ गया
एकदम प्रूफ है, कंकरेंट फाइंडिंग ऑफ फैक्ट है,
जो है सो ओरल है।
हाँ ओरल है,
क्यों ओरल नहीं हो सकता है
नहीं
हो सकता है, लेकिन जब आप कोई डिग्री को सर्कमवेंट करने के लिए
कोई डिग्री को
elections
सर्कम
लाते हैं, जब एक सब लाते हैं तब तो हम दिखाएंगे उसको।
नहीं रेस जुडिकाटा इशू बना, दोनों को फाइंडिंग दे दिया कि रेस जुडिकाटा से बात नहीं है, फैक्ट पर आप सब आर्गुमेंट
करेंगे।
ठीक है 5 तारीख को नए साल में नए सीरियस लड़ाई
नहीं, कम से कम इतना ठंडा
96 का सब कुछ नहीं, सिविल कोर्ट नहीं, सिविल कोर्ट बंद है तो कल सिविल कोर्ट से बंद है, सब मर गया है इसमें, कम से कम आप हो जाने
3
दीजिए,
तारीख को खुला,
Item 33.
कम से कम 3 तारीख तक तो कम से कम कुछ नहीं करेंगे।
कुछ नहीं होगा 3 तारीख तक हम
इतना ठंड भी पड़ रहा है, एकदम
नहीं,
एक्स्ट्राऑर्डिनरी ठंड है हुजूर इस साल।
ठंड में कुछ नहीं होने वाला, ठंड में जल लोग भी कुछ
ना
नहीं
बहुत
होगा।
ज़्यादा है।
yes
Where did that item number 6?
6
On parity, the matter traveled up to Supreme Court, that defense statement was acquisition under. So I have got that statement. Probably it seems that when they are, it is covered.
Yes.
What I intend that I want to bring that on affidavit instead of arguing, because for others the
ये
matter.
वही है ना जो आपके लिए फिक्स किए थे, इसमें तो टाइम होने का कोई काम ही नहीं था,
नहीं टाइम नहीं हम क्या instead of
कुछ एफिडेविट का जरूरत नहीं है इसमें।
instead of going into the entire facts material, we can, because 3-page noting I have received,
कोई बात नहीं, आपका नोटिंग हम देंगे।
तो आज हम उसको बोल रहे हैं उसको 5 तारीख को कर दीजिए। I am not taking time. It will cut short the entire
You
argument.
are taking time. You are taking time. On the last date, I
I
have
was-
simply said that I will not grant you time.
So then you should then go down, because I normally because this will cut short the entire argument. If that is the case,
नहीं कट शॉर्ट तो आज ही करिए ना, कट शॉर्ट करते हैं आप।
there are other 2 hearing matters, because I had to leave for the evening. There is I had to catch flight. But if your leadership is,
इसमें कुछ है ही नहीं ऐसा करने को। चलिए आपका केस अभी शुरू करते हैं, 10 मिनट लगेगा।
तो आने दीजिए उसको सीरियस में यहाँ।
सीरियटन क्या आपका तो लिखा ही हुआ है Act 250।
तो मेरा केस है, हम तो बैठे हुए तब से।
नहीं ये भी है, आपका तो है ही, आपका 2 केस है 215 के लिए।
तो पहले को
आप
करना चाहे तो कर लो।
I just verify this because I received just now received this 3 pages.
वेरीफाई कर लीजिए।
नहीं
Item 33.
बताइए।
This is complaint finding of fact. There is a, may also do not show up to first clear on the merit before going into the detail. But it's in nutshell, the case is, but it's the defendants have not filed WS. So it's a case of non-travelers. Now, but the plate, let's have a certified copy of the plate that will clarify what is the case, and then I'll come to the substantial question of law. Yes, ma'am. Now, the prayer in my plate was, notes, the plaintiff is already in possession of the suit land, as the plaintiff prays to declare the right and interest of the plaintiff of the suit land. The sale deed, this is important. The sale deed of the default number 3, dated 11/6/2018, wide number 2892, be declared null and void and not binding on the plaintiff, and the cost of the suit be awarded to the plaintiff. Minutes? Your lordship got it, minutes? Now the facts, please.
The sale deed number is, give me the sale deed number once again.
Yes, that is the sale deed number, which we have challenged this minutes. 2892 dated 11/6/2018.
11/6/18.
2018. Yes, ma'am? Now, what is the case runs like this, friends. Now, Daulat Ram Mia had two sons, Parmali Mia and Dharmali Mia. Now, Parmali Mia had thereafter four sons, Chatru Mia, Tehlu Mia, Manu. Before going into that detail, let me just say, very in simple words. Now, we both are deriving title from the heirs of Parmali Mia. Correct, Manoj? Now, from Parmali Mia, we have already purchased 21.75 decimals of land. The
You
total
are
area,
deriving title from Parmali Mia or
heirs
from
of
the heirs?
heirs of the Parmali Mia, and he is also deriving title from heirs of Parmali Mia. Now, the subject land is khata number 422, plot number 20. Now it is total 36 decimals of land. Now in the plaint, it has been specifically averred as to how the complete 36 decimals of land was sold by the heirs of Parmali Mia. That has been exhibited also. Initially 9 decimal was sold, and thereafter 21 decimals of land was sold to us. Now, what we have found in 2018 is the heirs who had sold us the land again resold the same land to defendant number 4.
Depend on.
4.
So 9 decimal of land was purchased in the year 1956.
Yes. 26/12/1956, that is also exhibited. And then our registered deeds by which we purchased, my lords, is total 21.75 decimals of land. So what we averred in the plaint was that the heir who was already sold us the land was not left with any other land. So once he was not left with any other land, the subsequent sale deed by the heir is wrong, bad, hence that sale deed be declared null and void. This is a case in nutshell.
So in order to show that the heirs of Parmali Mia had sold all the property,
Yes,
which all are the sale deeds?
the sale deeds are there, but the exhibits, then you will also come to the judgment.
Okay, 9 decimal 26/12/56. What else?
You know, those exhibits are there before. No?
You just tell us.
I'll just
9 decimal 26/12/86.
Exhibit 1A.
How much is the area?
Area we just like initially it was, but first it was 12.75 decimals.
No, which?
That's white sale deed number 371 dated 13/1/78.
No, this is not the first one.
Bharat?
This is not the first one. First one is 26/12/56. 9 decimal.
Oh, that is different. That is to Hamidan Bibi. That is with respect to that 36 decimals of land. The initially heir sold it to Hamidan Bibi, just to show that from 36 this 9 decimal land was already gone to Hamidan Bibi.
Okay. Now,
now-
36.
Now, so the first purchase by us was
Now tell us the account for 27 decimal.
yes, brothers. It is minutes 12.75 is white sale deed number 371 dated 13/1/78.
12.75.
75.
This is dated
This is dated 13/1/78.
13/1/78.
This is exhibit 1A. Then the second is exhibit 1B.
1B. Dated area
This is 26/8/1982.
26/8/1982. Area
Whereas the total area as mentioned therein is minutes. I just from the plain title minutes on this. The rest area they have purchased minutes. Is here at what's para 9 of the plain minutes, details minutes. But this 3 decimal was sold by Alibak's Mia. 3 decimal was sold by.
Who is Alibak's Mia?
He is also the heir of one of the heirs. The details have been mentioned.
No, it can't be like this. You have to give
But
me
that
the
details.
exact breakup.
I'll give the exact. What is what the point of law?
Because your case is that no land was available for sale.
Yes, exactly.
So show us.
I just showed Manoj that the land which was sold to me by the heirs are the same person who have tried to sell the land to the other party.
See,
Now they have not traversed that fact. They have not.
maybe they may not have, but you have to establish your own case.
My own
Your
case was
specific
sensitive.
case is that the entire property
My
was sold.
details, my
Now
details,
show us that
my
what
details.
before this particular impugned sale deed, the
My-
entire property was sold.
Yes, Manoj, that we have mentioned in the
Mention आप सेडिट नंबर पूछ रहे हैं तो आप बता नहीं पा रहे
सिडी नंबर एग्जिबिटेड है सब सिडी पे एक्चुअली तोड़ के टुकड़ा टुकड़ा करके उसको ये निकाला गया है
जीवन ही टुकड़े टुकड़े में चल रहा है. It is always like this. इस तरह के dispute में ऐसे ही
It's
होता है.
always like this. तो 21.75 का उसने मेजर जो है पूरा पैरा 9 और 10 में डिटेल में दिया है. आई एम रीडिंग दैट वर्ड्स दैट वी
रीडिंग में आप हमको ब्रेकअप बताइए. रीडिंग तो हम
उसको ब्रेकअप करके हम दे देंगे. Actually, because of your lordship's only direction, I was yesterday I was afraid. मेरा बहुत हालत खराब था. I was in my suffering from my. लेकिन अब आए because just to honor your lordship had directed me to appear.
आपने एहसान
अरे नहीं वो नहीं.
तो हम इसको एडजस्ट कर देते हैं because you are not ready with the matter.
Aha, that your lordship is right. Your lordship's correct. I will not deny that. I was just ready on the point that just to show.
Essay number 191 of 2025. The counsel for the applicant, Mr. Sailesh Kumar Singh, has appeared. As on the last occasion, it was made clear that no further adjournment will be granted. However, it appears that he has not been able to fully go through the records. He has submitted that otherwise also he is not ready. I will request post this case on बताइए कौन सा तारीख? Any date मत बोलिए. Any date बहुत खतरनाक होता है यहाँ पर. वो danger है.
नहीं वाकई
चलिए फिर जाएंगे.
ओपनिंग डे पे
हो गया ना ये any day में दिक्कत.
ओपनिंग डे
The learned
थोड़ा
counsel
सा
for the applicant is directed to prepare a short synopsis of the matter.
Opening
and file it on 5th, post on 6th.
7th कर दिया जाएगा, फिर 7th कर दिया जाएगा। एक दो दिन में चूंकि आने में मान लीजिए कॉम्प्लेक्स में कुछ भी हो जाए तो
6 तारीख को 5 तारीख को आ जाएगा, तबीयत ठीक हो जाएगी।
7th को, अच्छा 6th को।
Item 26.
आपका joint compromise है?
Yes, I have done this part.
Who is for the other side? Somebody was appearing on the last date.
Yes, because of some
There is
happening.
कहाँ है आपके other side? कोर्ट के बाहर हैं। आपको फोन किए थे ना, आप भी उनको फोन करिए।
खबर
मतलब वेट करिए।
Item 6, first appeal 43 of 2018.
At the very outset, two things that my senior friend from the side has submitted, that for this village Tumbaktu, this is under RAIP,
Villages
Tumbaktu. He has given this notice,
Tumbaktu.
Tupakutu.
Tumbaktu. Proper noun it's always
T-U-M
B-A
B-A
G-U-T-T-U.
G-U-T-T-U.
So that's proper noun that liberty.
1952.
1950. Now before I proceed, madam, there is
What is the date of requisition?
notification is
Requisition.
acquisition.
13/1/1987.
And acquisition?
Notification is Exhibit R.
I will give that.
Notification is दो date पूछ रहे हैं sir. What is the date of requisition and what is the date of acquisition?
Requisition is 1942.
19. And acquisition is
13/1/1987.
1980. Appointment of arbitrator date. Appointment of arbitrator date.
Arbitrator date appointment is that one. It's a this matter will be the several arbitration.
In the present.
The case was CWJC 3784 of 1998 R and date of appointment
3784
of 1998
1998
R
R.
and the date of appointment will be precisely
17/3/2010.
17/3/2010. Yes, and the arbitration case is 3 of 2010.
Year
2010
2010.
and Justice Vikramaditya Prashad.
What all has he awarded? He has enhanced the compensation.
Yes. I'm just listening. That we will should come to.
Any solution interest?
Yes, yes. That is
Solution at what rate?
9% is the interest and 12% is the interest is 12%
Post award interest.
Post award 9% is the interest that is granted, and solution is 12%. Just please. So page 14, I'm just placing. Solution is 20%. Interest from 13/1/1987. That is at internal page 14 of this area.
Yes, 20%.
Yes. Valuation of the total land acquired shall be 2 lakh per acre. 20% will be the solution. Then interest from 13/1/87 on the residual amount to be paid to the claimant till date of award, 9% per annum for 25 years, 2 months. That was the date of it. And then cost of arbitration is 3,000. Office expense also 3450, that is 1 lakh. And then post award it is 12% interest.
Good.
Now the order in line of this judgment of the same village that traveled up to Supreme Court, where we are also disbursing the payment. So I am instructed to say that there is an appeal before village, but I don't find that there is any material difference between the claim, and parity has to be maintained. That was the only thing that I wanted, that they should come with an affidavit before
That's
village.
always.
And so
You are not an ordinary advocate anymore.
no, that's there, but concession on affidavit.
There is no question of concession.
So,
If
So,
it is parimeteria, it remains
the
parimeteria.
same village, this three, my learned senior friend has
Yes.
given these 3 documents. These are pertaining to different arbitration of the same village for same requisition and acquisition.
Which are those 3?
These 3 probably missing.
One is first was Chunda Ora and others.
He has given.
Chunda Ora and others.
Yes. So there, ultimately, what has summed up is
पहले चुंदा और वाला जजमेंट देख सकते हैं.
Yes.
This is again finality.
this has attained finality.
Okay, let us have a look at it.
So first appeal order or Supreme Court? Supreme Court is 2 line. That is
No, therefore first appeal told
Yes, that-
because Supreme Court might not have entered into
no limitation on point.
That's-
No, thereafter, again they moved with regard to Chunda Rao in Supreme Court. That was the second SLP.
against the same award.
Yes. And in that there was a cost imposed by the.
We are not bothered about
No,
this,
no.
sir. Let's be
Yes.
Well, sir, finality is the issue.
finality.
My,
is the
my,
issue.
my litigation exercise
Yes.
is not the issue. This, I am coming to that order. Order will start from page Yes, this is MA annexure 2. It will be pagination. Pagination.
Substitute हो गया.
Yes. Your leadership is there.
Just tell us which one. MA number.
MA number, that is good. Now, at that point of time, it was miscellaneous.
Yes, MA number
132, 38 of 94.
38. Forgot it.
Annexure 2.
Now let's have a look at it.
Yes.
Sanjay.
So, this award, the main part I will ask from you.
Yes.
Other rupees are discussed. This page, internal page 11, parallel 50.
Yes.
May replace this one.
Yes.
Taking the ratio of all the above mentioned judgment of the apex court, it can be formulated in the following manner. Under the Act of 1952, when there is no provision of solution and interest, then it must be held that ordinarily there is no jurisdiction of arbitrator or court to grant solution and interest in the compensation assessed as due so and so, and the Land Acquisition Act 1894, and there is omission in the Act 1952, then it must be held that omission was permeated and with intention. And the
In the present case, नीचे आइए ना, principal का हम लोग इतना दिन से सुन ही रहे हैं आपको टैक्स नीचे आइए.
Actually, today I am in trial. In the present case, applying the said principle, normally I would like to go without going through a direct brief. So,
In the
in
present
case
case,
applying the said principle, it could be found that although the compensation was assessed at a very low rate, long back the claimant appellant took objection in the matter and asked for referring the matter to the arbitrator. But the same had not been done, and the claimant had to come to the writ petition before this court. Then a direction was given by this court. And I will skip for 5, 6, 9, 7.
acquisition took place in
The learned,
1985.
the last 4 lines, the learned
Yes.
arbitrator has considered those aspects and considering different rulings and awarded interest and solution in the nature and circumstances of the case. Solution has been granted at the rate of 15% and interest at the rate of 12%. It is submitted by Mr. Mehta appearing so and so that practically solution and interest as granted is not at par with the mandatory provision of Land Acquisition Act. I will just come to find
Now,
it.
para 19, the main
Yes.
objection.
Yes. The main objection in this appeal is with regard to the solution and interest as granted by the learned arbitrator, which has already been dealt by me in the following paragraph, while the 2 other appeals, MS so and so, which were heard analogously with this appeal. Another ground has been taken regarding Exhibit A1 and A5, certified copy of certificate. Accordingly, Mr. Chandra, appearing on behalf of the appellant, Mr. so and so, such discarding is improper. The Section 46 of CNT Act was not constitutionally valid at the relevant time, but this point has already been set at rest by full bench of this court, in which I was also a party. And as such, rightly, those CLVs had not been taken into consideration by arbitrator. Thus, this appeal has also got my say. So ultimately, what I find that solution
Ultimately, the award was
upheld without any interference.
without any interference, whatever be the reason.
Yes, whatever be that. So we have to fall back to the what was that? That is internal page which I pointed out.
So, award was upheld.
Okay. And 12% interest, post interest, probably that judgment travelled up to the Supreme Court.
Yes.
And that survived.
That
Post
was-
award
that
interest
was
also.
confirmed. That was confirmed. 12% interest he to pay upon
Where
the.
is that order?
Yes, that is in
1995 that reported judgment which may not be
no, 2010.
2000.
Where is that? Sir,
That
आप
is-
पेज नंबर ही नहीं करते हैं
अभी?
अपने petitions का, तो बहुत ज़्यादा दिक्कत है.
That is in the matter of Sedat Munda, last one. This is reported judgment in 2010.
सर आप ऐसे बोलेंगे तो हमको नहीं, आप हमको बताइए कहाँ है? Where is it?
Regarding
In
this,
the matter of Sedat Munda and others versus Union of India and others.
last page.
कौन सा ऑर्डर पढ़े सर, आप हमको बताइए ना, नंबरिंग है आपके बंच में. What should I read? You say that there is an order of Supreme Court, you just tell us which order is that. Which order should I read? You just tell me.
The third compilation, it is not the one, 3 compilation he has given.
बताइए।
He is referring to
ये
स्नेथ
है
मुंडा। स्नेथ मुंडा ये जो आप देख रहे हैं, उसमें और भी होगा।
Senate Munda is also for this village.
See, this village arbitration is different. Like in this arbitrator was Ram.
No. In this arbitrator was Honorable
Smith
Mr.
Munda, you
Justice
have-
LPS Sir.
Venkateshwar has got this in compilation. Last but 4 pages. It is the finding would be at
You see, there was a direction to pay interest at the rate of 9% till the date of the award. No problem. There was a direction to pay post-award interest at the rate of 12%. And then your dispatch 12.
Yes,
So post-award
12.
interest has been upheld practically.
yes, that's what we find in peculiar facts of this case, because we had given that judgment of ethics for there it was said that it cannot be done. But for this case it will apply because now it has attained finality.
Yes, the award has attained finality.
Finality
And it was only 12% interest post-award.
post
Instead of 9%, it would be 12%.
12.
Simple.
So
There is no question of any compound interest.
that is not reflected. That is
It
what
is not reflected.
It is not.
Instead of 9%, it would be 12%.
12%. So for this case, my submission would be that for this case it will be a binding precedence because parity exists, and for the same village, Lumbagu
we can simply say that
if I frame the
case
proposition,
is-
if I just frame the proposition,
Yes.
that acquisition of 42 followed by acquisition of 87, several arbitration proceedings based on the aggrieved party were initiated pursuant to the order of this honorable court in different repetition. I will ask my office to prepare a short video this time. And based on that, some of the arbitration awards were there which were put to challenge in miscellaneous appeal, or for that matter first appeal. Matter travelled up till Supreme Court, and ultimately Supreme Court did not interfere with the award. Consistency in the award was maintained in every case.
That's
Seeing that the land rate solution
and one of them is this one,
Sneha Munda.
Chunda Munda.
Yes, one is Chunda Munda, 3 he has given.
और
Chunda
तीन
Ura.
बता दीजिए ना कौन सा एक चुंदा उड़ाव है
हाँ, Sneha Munda,
एक
UNDA, Chunda Ura and others.
इसमें MA नंबर
इसका MA number 38 of 94. There are analogous cases.
38 of 90
And analogous cases.
That's right, that's right. और दूसरा कौन सा है
Sneha Munda, SENETH.
SENETH
Munda and others.
Munda. This is MA number.
This is MA number.
This is post.
This is
First appeal 107 of 2003.
First appeal 107
7
of 2000.
3 disposed on 27/4/2007.
24
27/4/2000.
27/4/2007 और MA का डिस्पोजल कब का है?
MA का disposal है इसमें first appeal है. That is the
First
first. This time first appeal because of High Court rules. Now it
नहीं
is
ये वाला चुंदा उड़ाव का disposal
चुंदा उराव का miscellaneous appeal का disposal date है 9/3/1998.
9/3/1998. ओके ये दो
और एक और है.
बताइए
Sukher Ullah.
That is Sukhar Unnao,
सुखर
SUKHER,
SUKHER
Unnao and others. और इसका फर्स्ट अपील है 2 इसमें से 83 of 99
83 of 99
against the award dated 27th May 98 and first appeal 275 of 99 against the same date of award.
Just a moment. FA number
275 of 99 R.
83 of 99.
Yes,
दूसरा
275 275
275
of 99
99.
under bracket R.
इसमें भी R होगा ना?
R
Against the same award.
against the same award 27th of 98 dismissed on 13th of September 2000
13/9/2001.
2001.
Okay. In all these cases, the solatium and interest has been applied
Yeah.
in the same manner,
Same manner.
as has been
Yes,
involved
yes.
in the case.
So we so when confronted with this question, Union of
The
India,
advocate.
so confronted with this situation,
Yes.
Union of India says that there is.
We'll take
Yes.
it.
So if taken the first page, no, he has given that noting part. If you leadership will have a first page, the senior friend.
This one,
First page of every
all these
company.
things, yes. He's
CW.
given that.
Yes. And that is first CWJC is for appointment of arbitrator under 8(1)(b),
That's it.
followed by arbitration case, followed by appeal.
Appeal and
Then followed by
another appeal.
LPA also, and then SLP. These all details are there. So this can be
एक, दो
and
और ये
तीन.
तीन का काम ही लिख देना।
तीन का
इसी का
काम
चार्ट बना दो।
उसी का फर्स्ट आएगा ही दिखा जाता है।
For the learned counsel appearing on behalf of the parties, this appeal has been filed challenging the award dated 5/4/2012 passed in arbitration case number 3 of 2010 by the learned sole arbitrator in exercise of power under section 8(1)(e) of the requisition and acquisition of immovable property Act 1952, hereinafter referred to as the Act of 1952. The learned counsel for the appellant has, at the outset, the learned counsel for the respondents has submitted that the acquisition relates the date of requisition under the aforesaid Act of 90, the date of requisition by military
Defense.
by defense is of the year 1942, and the date of acquisition is
13/1/87.
13/1/1987 under the provisions of aforesaid Act of 1942. He has submitted that although there is no provision for award of solatium and interest under the Act of 1952, but considering the delay on the part of Union of India in the matter of appointment of arbitrator, who was appointed only after the claimants moved the High Court in writ jurisdiction, the learned arbitrator has awarded solatium and interest. Solatium has been awarded to the extent of 20%. The compensation has been enhanced to rupees 2 lakhs, and post award and further interest has been awarded at the rate of 9% up till the date of the award, and post award interest has been awarded at the rate of 20%. The learned counsel submits that arising out of same date of requisition and acquisition.
Same requisition and acquisition. The date means
Okay, say arising out of same year of acquisition,
requisition first. It will
the
be
same year of requisition,
followed by acquisition.
followed by same year of acquisition.
Acquisition.
There has been number of litigation before this court, and different arbitrators were appointed by virtue of orders passed in different repetition. He has submitted that in all of them, the award of solatium, interest, and the rate of compensation with respect to the land is one and the same. He has submitted that the awards were challenged before this court by the Union of India. The challenge was declined, and ultimately those awards have attained finality. The learned counsel submits that there can be no reason to take a different view in the present case. Right? He has given the details as under. ये 3 bunch है. ये
First, second page will be.
first page का सब कर.
Second page also.
Second page में.
SLP has second page.
ठीक. ये detail देते हैं. Being faced with the aforesaid submission of the learned counsel appearing on behalf of the respondents, the learned counsel for the appellant, Union of India, has not been able to dispute the aforesaid factual situation which has been placed by the learned counsel for the respondent.
Rather, he is on an instruction that those amounts are in the process of being disbursed.
Rather, he has also submitted that he is under instruction that the compensation assessed in the other cases is in the process of being disbursed. He has fairly submitted that otherwise the case is covered. Should I record or should I?
It is on
That
parity.
should be sufficient.
That will be sufficient, and I will say that for this case, the principle, he argued on the principle that post interest is not maintainable, but for this case, since Supreme Court has interfered, so parity will come into. That will be the case.
However, he has submitted that post-award interest is not permissible in the eyes of the court. After hearing the learned counsel for the parties and considering the
Solution will be applicable, post interest or solution.
interest, post-interest and solution is not there. Considering the arguments advanced on behalf of both the parties and the fact remains that arising out of the same village and requisition of the property by defense in the year 1942 and acquisition of the year 1987, and the fact that the Union of India had appointed the arbitrator only after filing the writ petition before this court, and in the present case it was by virtue of writ petition being CWJC number 3784 of 1998, that R, dated, which was disposed of on 17/3/2010, giving rise to arbitration case number 3 of 2010. This court finds that the learned arbitrator has considered this aspect of the matter while awarding compensation, by awarding solatium as well as interest
Internal page 14
at internal page 14
of the
of the award.
Para 21.
Yes. In paragraph 18 to 21 as under. This court finds that the present similar awards arising from the same village,
It will be 22 then. 12% has been taken into consideration. Para 22.
para 22,
18 to 22.
18 to 22. Considering the fact that under identical situations, under similar situation, the award has been passed on similar lines and have attained finality, this court finds no reason to interfere with the appeal. Accordingly, this appeal is dismissed.
DP orders.
Well, may I submit one? In the chart prepared by the Honorable Arbitrator, there is some mistake.
Rectify now. यहाँ कैसे rectify?
No, not with regard to the amount.
Sir, I will not enter into this. ना तो आपने कोई cross अपनी फाइल किया, ना कोई cross objection फाइल किया है.
Otherwise, also the arbitrator has mentioned that the question is to be.
Great.
Sir, इसका execution कैसे होगा? Sir, आपसे पूछ रहे हैं. If they do not pay, how will you execute this?
Not in this case. With regard to
In general 1952 Act में execution कैसे होता है?
payment is to be made by the deputy commissioner.
उन्होंने execute कैसे होगा?
There is no provision of exclusion. Therefore, I have filed in 2 cases I have filed the writ petition also, and in which they have made the payment. In the act, there is no provision of exclusion.
एक second sir.
Therefore, I have filed the.
Just a minute. In case there is a dispute regarding quantum, in case there is a dispute regarding entitlement, these things is contemplated in the act, and there is a direction to deposit the amount in the court.
Yes, that can be. And what is?
So the court gets the custody of the money.
Yes.
Then the court will execute it.
Yes.
Which court? High Court.
In all the cases, in one case it is High Court. Otherwise, in all the cases, deputy commissioner is competent authority under the Act, Section 2B. Therefore, it may be sent to the deputy commissioner because earlier also the disbursement has been made by the deputy commissioner, either High Court or at any place. I am agree with
I
parties
don't
to
want to
get money.
decide this.
This
This
will
is
give.
not the stage where I should be deciding this.
In
But
one,
there is a provision in the Act. In case of any dispute, the amount is to be deposited in the court.
That is the
Court means civil court only, not the High Court. High Court will not
High Court
decide the
otherwise
apportionment.
also High Court does not come within the that
No, yes.
another arbitration
Court
also.
means
Civil court of principal jurisdiction.
जब वहाँ पैसा जमा होगा तो एग्जीक्यूट भी तो वहीं पर होगा ना, रियलाइजेशन तो वहीं से होगा ना,
वही implication है उसका.
वही implication है उसका.
again, from the initial stage, under Section 2B, the competent authority means any person or authorized authority the set of the settlement by notification.
तो दूसरा केस के लिए पूछ रहे थे.
And
सर आपको इतना एक्सपीरियंस है लैंड एक्विजिशन का, इसीलिए आपको दूसरे केस के लिए.
नहीं एक्विजिशन केसेस में जितने भी केसेस आप देखेंगे उसमें
No.
रेफरेंस में कोर्ट में ही जमा होता है. जैसे हम चैलेंज भी करते हैं अवार्ड को इन लैंड एक्विजिशन एक्ट
हाँ,
कोर्ट में हम जाके जमा करते हैं. That is
court
the
is here. The court is in land acquisition also. The court is the deputy commissioner. It is not the court. Is the notification is there. It is notification there. I can show the notification. In all the cases, when the order has been passed, the money has been deposited in the office of the deputy commissioner, and here the notification of 1952. All the collectors in the state of Bihar, the area falling within their respective jurisdiction. It is notification.
Item 26. SA 419 of 2016.
compromise.
Yes.
All the parties have filed their.
Yes.
How many parties have been exempted from substitution? Because that has to be recorded.
5 to 16 respondents.
Five to not expunge, they have been
Exactly.
exempted from substitution, and their name has to be deleted subject to any objection. We have to record that, we can't omit that. By which order we have done that?
28/11/2025.
Rest of the persons have done it. The KSA number 419 of 2016. The learned counsel for the parties are present. Terms of compromise is from para number para 3.
There is description of the land.
The learned counsel for the parties have jointly submitted that the parties have settled the dispute outside the court, and consequently a joint compromise petition has been filed through ID number 170044 of 2025. they submit that the appeal be disposed of in terms of the compromise. They have in particular referred to paragraph number 3 to 25, and I submitted that under paragraph 25, the details of the property has been mentioned with regard to the respective parties. During the course of hearing, it transpired that by order dated 28/11/2025, IA number 12470 of 2025 seeking exemption from substituting the deceased respond number 5 to 16 was allowed at the risk of the parties and subject to any objection that may be raised by one or the other person. Accordingly, the deceased respond number 5 to 16 had not been substituted in the proceedings. इसको जब ऑर्डर बनाइएगा ना तो उसमें लिखिएगा ब्रैकेट में deceased dash exempted from substitution by order dated 28/11/2025, subject to any objection that may be raised by one of the others. ये हर एक के उसमें लिखिएगा, ये 5 to 16 करके लिखिएगा. आप डिलीट कर देंगे इनका नाम तो आप लोग डिलीट कर देंगे. डिलीट तो करना पड़ेगा ना नाम.
I do.
The learned counsel for the applicant is directed to delete the name of respondent number 5 to 16 from the constitution. After hearing the learned counsel for the parties, this appeal is disposed of in terms of the compromise. The IA number 17044 of 2025 shall form a part of it.
Office may be directed to prepare a
Yes,
ticket.
office will prepare. Email. उनसे बस यही हमको पूछना पड़ेगा. बुला के कभी पूछ लेते हैं कि वो लोग कैसे incorporate करते हैं. Because the exact details should be incorporated.
हाँ, वो थोड़ा इसमें बहुत ही मतलब वो है मतलब बनाने में ही
नहीं तो वो हमें ध्यान में देना जरूरी है क्योंकि कुछ गड़बड़ हो जाएगा तो
हाँ नहीं
क्योंकि बाद में ये सारे रिकॉर्ड डिस्ट्रॉय हो जाते हैं. So that we have to take care.
Obliged.
Item 1, second appeal 85 of 1994.
हाँ फर्दर हम लोग का आर्गुमेंट रिकॉर्ड का लॉर्डशिप ने सेड क्या
Actually, I am busy with one CAP matter. That I will not be. I will reserve this or maybe क्योंकि हमारी तरफ से तो आप लोग का तो सारा कुछ ऑलरेडी
सब कुछ हो चुका है, आर्गुमेंट हो चुका है, जो जजमेंट था वो भी हम लोग रेफर कर चुके हैं।
इनका हम एप्रिसिएशन रिकॉर्ड करते हैं, आपका एप्रिसिएशन तो याद रखिएगा, ठीक है? अमाइकस सेंस
But there is one judgment she was showing, so you can
Of
take that
course.
judgment. नहीं, ये she was not very कि ये judgment आप खोल के लाए हैं, हम बोले place that judgment because you have researched, so we will definitely.
which judgment is this?
Lordship, it is civil appeal number 411/2009 from Distur Sahab dead and others versus Salima and others.
What is it?
Lordship, इसमें बस ये clear किया गया है कि what is the major difference between Mohammedan law and the Hindu law, which was queried by Lordship. And it is clearly in paragraph 13 to 17, it is clearly mentioned what are the major differences. In paragraph from reading paragraph 13, Mohammedan law being the personal law possesses its own legal principles and regulations which govern family relationships in matters such as marriage, divorce, inheritance, custody, and guardianship. Its distinctive feature sets it apart from other personal laws on fundamental issues. It is pertinent to examine the legal principles, if any, governing partition under Mohammedan law. Paragraph 14. It says that I just read the whole paragraph.
You can just summarize it. उसको बंद कर दीजिए, आप बोलिए.
जो बेसिकली इसमें बस ये है कि जो पार्टीशन है उसमें सेपरेट मेस एंड कल्टीवेशन वाज द पॉइंट वेयरइन वी वर कंफ्यूज्ड कि द हिंदू law will be implicated,
The principles
will be in the Mohammedan law. So it's been clearly mentioned in this that the basis of partition between Mohammedan law and Hindu law is very different, which is tenets in common in case of Mohammedan law and in case of Hindu law, which is joiners. So in that case, it is not applicable to the Mohammedan law. That's
So if there are 10 properties, so 10 properties are to be separately partitioned. Or is there any concept of joint possession? Is there any concept of joint possession?
No, there's no. As per this,
There is no unity of title, but there is a concept of unity of possession in Mohammedan. In Hindu law, we have unity of title and unity of possession with respect to ancestral property. But in Mohammedan law, there is unity of possession, but there is no unity of title. Essay number 85 of 1994 within the R, the learned counsel for the learned amicus appointed by this court has placed the judgment passed in.
But she has got 2 copies. One by Lordship also.
The judgment passed in civil appeal number 4211 of 2009 with bracket Mansoor Sahib with bracket Del bracket Rule and others versus Salima with bracket B by Elas and others. Decided on 19th of December 2024. She has in particular referred to paragraph number 13 to 17 of the said judgment to submit that the Honorable Supreme Court has drawn a distinction between the Mohammedan law and Hindu law in the matter of partition. Order is served. अब आप अपने टेबल में जाइए, मिस्टर सानी को बोलिए जितना भी मोहम्मदन लॉ वाला केसेस हैं सब छांट के दे दीजिए और आप बहस करें. You must be having many cases, I know. Many second appeals and first appeals.
जब रेमिकस क्यूरी होके इतना मेहनत की है,
हाँ,
तो
तो कम से कम बेसिक्स तो पता चल ही गया होगा.
नेचुरली
इतना अच्छी तरह पता है ये, तो बता दे. एक लाइन ऑफ लॉयर्स को हम लोग खड़ा कर देना पॉसिबिलिटी बहुत जबरदस्त पेक्यू हो गया आपकी मोनोपोली खत्म करनी आपका ये जो मोनोपोली चल रहा है ना खत्म करना
For hearing on order 4111 item 3, second appeal 442 of 2003.
Last this matter was taken up last week. It was pointed out that respondent number 4 is right. We have filed an IA, but it is not IA for substitution and setting aside abatement.
when did you get
We had given to file in 2-3 days back, but I am told that today it has been numbered.
anyways you just give me the date I take the date from you I pass an
Uh,
order to
uh,
that
We
IA
don't have the
number has
exact.
been numbered
That
give
is
me
my
the
correct.
IA number was आज ही इसकी
Date of the tentative because they did not file any, the respondents did not file any application at 22/10. But what we have come to know is October 22. But exact date we don't know.
October 22 please respondent number
4.
4 okay and what are the who are the legal entities?
We have mentioned in para 7 of that
17375 of 2025 इसको खोज के लगवा लेना para 7
para 7.
they are all residents of Jharkhand
Yes.
notice has to go SC number 442 of 2023 Council for the applicant has submitted that IA number 17375 of 25 has been filed seeking substitution of deceased respondent number 4 who is said to have expired in the month of October 2020. The learned council submits that a prayer has been made for condonation of legal and setting aside abatement. He has also submitted that no petition under order 10A has been filed by the respondents and the matter has been pending with police court since the year 2000. Issue notice to the proposed legal heirs and successors of respondent number 4 whose details has been mentioned in paragraph 7 of the integrity application for which requisites under speed post and ordinary process be filed by 6th of January. Office to tracks the news delivery. Post this case on today. Fifth of February. 9th of February.
For the respondent number 6, we don't have the copies of second appeals.
You furnish it. You need what? You need only copy of the memo for that should be sufficient.
Yes.
You can create its record. Give you a memo.
Yes.
For hearing on order 4111 item 27, second appeal 429 of 2017.
May please your lordship. This is my lords, the defendant's second appeal against the judgment of affirmance. Lordship, suit was filed for declaration that the plaintiff number 3 and plaintiff number 4 are co-partners of defendant number 1 and 2.
Plaintiff number 3 and
Plaintiff number 3 and plaintiff number 4 are co-partners of defendant number 1 and 2. and the plaintiffs, my lord. And further prayer was made that the plaintiffs are not bound by the collusive decree passed in partition suit number 20 of 1977.
You were not party?
Yes,
Were you party?
Lordship. In this case, my lord will find that, my lord, in partition suit number 20 of 1977, compromise decree was passed. Lordship, if compromise decree has been passed in partition suit, that cannot be challenged by filing suit. Lordship may kindly see the provision contained in section 20.
Who has challenged it by filing?
Plaintiff, I am the defendant.
By saying that it is collusive?
Lordship. Now, Lordship may kindly see the provision contained in Order 23, Rule 3A of the Code of Civil Procedure.
That has been brought in by the amendment.
Yes, suit is barred.
No, that amendment is what date?
Lordship may kindly see.
That is. This is order?
Order 23, Rule 3A.
This has been inserted with effect from 1 to 77.
Lordship.
When was this partition?
Lordship. But this suit, my lord, is of the year 1990.
Okay. When was this compromise decree passed?
Compromise decree was passed, my lord, on 24/1977.
What is the prayer in the suit? Let's have a look at it.
Lordship mechanism. Declaration that the plaintiff number 3 and 4 are co-partner of defendant number 1 and 2 who are
Yeah,
made
but plaintiff number 4 and 5.
3 and 4. Plaintiff number 3.
Is there a decree also? Declaration that plaintiff number 5, 3 acha, 5 is a
3
5 and 4 are co-partners. Can you read it?
Plaintiff number 3 and 4 are co-partners of defendant number 1 and 2 who are male members of the joint family which owns the suit property described in the suit below, and that the plaintiff as members of the said joint Hindu family are not bound by the collusive partition suit number 20 of 1977 of the Court of Special Sub-Judge Ranchi, disposed of terms of collusive compromise petition which form part of the decree.
Now, you just demonstrate.
Lordship.
You are the defendant, right?
And the defendant.
You show us that you were not a party in the compromise decree.
Lordship, partition suit.
Were you party in the compromise decree?
Yes, partition suit was filed by Tara Devi. Tara Devi, my lord, along with defendant number 1, against, my lord, defendant number 3. Partition suit was decreed in terms of compromise. Now, my lord, the only remedy.
The plaintiff were party.
No.
The plaintiffs were not party in the compromise decree.
Lordship.
It is not binding on them.
But, my lord, the plaintiff cannot challenge the.
It doesn't make any difference. A person who is not a party.
Lordship may kindly see there is a specific finding by both the courts that compromise decree has been obtained by practicing fraud. How can
See,
he?
the point is, if there is a compromise decree, it will not be binding on them. How does that make a difference?
Lordship may kindly see the findings of the trial court.
Decree between two persons is not binding on third.
That is there, but my lord, on that basis, On that basis, they have claimed that they are co-partners.
Even if let us assume that it is not collusive, how does that make it?
Lordship may kindly see the findings recorded by the trial court with respect to issue number 8. The trial court came to a specific finding that it is the self-acquired property of Dulli Chand Sarma. Then we are very the question of
The
inheritance.
point is that in a family, if there are 4 brothers, 2 of them they go and file a partition with respect to the entire property, right? And there is a compromise decree in connection with those properties. Then it will not be binding on other 2 brothers who are not party to this.
But Lord, they are challenging the compromise decree.
We have to see
on the ground that it has been obtained by practicing fraud, and suit itself is not.
What is the nature of fraud?
Lordship may kindly see.
What is the nature of fraud
Because the defendant number 1 was not made party in the partition suit.
Certainly, that is the
So
nature of fraud.
that can be challenged by filing miscellaneous case. Moreover, Lordship may kindly see the findings of the learned trial court and the first appellate court, in which it has been held that the suit property is the exclusive property of Tara Devi, acquired by her through valid gift deed dated 27/1949. That gift deed has never been challenged. Lordship may kindly see the findings recorded by the learned trial court, issue number 8. Page 45, Lordship may kindly see the findings of the trial court. Defendants argued that the suit property was acquired by Dulli Chand Sarma. Dulli Chand Sarma subsequently transferred the suit property to Srimati Tara Devi Sharma by virtue of registered gift deed, and Tara Devi Sharma was given possession of the suit property, and she came to hold and possess the same as owner thereof. The said property never belonged to Hindu joint family, and Dulli Chand Sharma was not the karta of the joint family. Dulli Chand Sharma and his 2 sons never constituted any joint family, or the property was acquired from the joint family funds. On the death of Dulli Chand Sharma, the property did not devolve upon the heirs of Dulli Chand Sharma. Plaintiffs argued that suit property belonged to the joint Hindu family, of which since deceased Dulli Chand Sharma was the karta, and his 2 sons Amar Kumar Sharma and Samir Kumar Sharma were co-partners, while his wife Srimati Tara Devi and his daughter Sheila Sharma, now Sheila Bashir, were family members. The suit property was acquired from the joint family fund, and it was all along recognized, dealt with, and declared as joint family property, and after death of Dulli Chand Sharma, Amar Kumar Sharma became the karta of the family, being the eldest member of the family. I find that plaintiff number 1 PW12 Krishna Devi admitted in examination in chief in para 2, not in cross examination, that the suit property is the property of Dulli Chand Sharma, and the same is corroborated by PW4 in para 1, PW5 in para 1, PW1 in para 1, PW9 in para 2, and PW11 in para 1. Now, Lordship may kindly see the findings recorded by the trial court. Next page, Lordship, page 11. Hence, it is established by above admission of the plaintiff that the suit property was.
This has been decided in your favor. This issue has been decided in your favor.
But my lord, suit has been decreed. This issue has been decided in favor of the defendant, but suit has been decreed. पहला हुजूर सब्सटेंशियल क्वेश्चन ऑफ लॉ खाली देख लीजिए. फर्स्ट अपीलेट कोर्ट का भी यही फाइंडिंग सेम. इवन देन सूट हैज बीन डिक्रीड.
इसी को बना लो और the learning council for the applicant. The learning council for the applicant has submitted that there is a concurrent findings recorded by both the courts that the suit property is the exclusive property of Tara Devi pursuant to execution of gift deed, and she was the absolute owner of the property. The defendants are the descendants of Tara Devi. He submits that on the face of such finding, the suit filed by the plaintiffs claiming the same property could not have been given. He has referred to substantial question of law number 1 as suggested in the memo. After hearing the counsel for the applicant, this appeal is heard and on the following substantial question. 2 का 1. Appellate court का भी same finding है.
Same.
कहाँ पर है appellate court का finding? यहाँ पे तो है as per discussion.
जी.
ये अजीब तरह से नहीं करते.
अजीब तरह से क्या दिया? दोनों कोर्ट फाइंडिंग दे दिया कि ये सेल्फ एक्वायर्ड प्रॉपर्टी है और उसके बाद उनको राइट भी दे दिया प्रॉपर्टी. हाउ कैन इट?
Appellate court ने set aside किया.
सेट डिक्रीड इन पार्ट हुआ था, उसको सेट असाइड कर.
इसको
सूट वाज डिक्रीड इन पार्ट, उसको सेट असाइड करके इनको को पार्टनर का तो सवाल ही नहीं है जब ये सेल्फ एक्वायर्ड प्रॉपर्टी और कंकरेंट फाइंडिंग है दोनों कोर्ट. स्पेसिफिक केस है हुजूर प्लेंटिफ का कि कॉल्यूसिव डिक्री वाज ऑब्टेन्ड बाय प्रैक्टिसिंग फ्रॉड. दैट
ठीक है.
जी.
Issue notice to the responses for these recusals under speed post be filed by 5th of January.
लोअर कोर्ट
Let
रिकॉर्ड.
the records be called from the concerned court, post this case on 9th of February, office to tax be posted.
अपील में भी एडमिटेड.
हाँ, please.
Item 28, second appeal 216 of 2018.
This second appeal by the defendant, respondent, appellant against the judgment of reversal.
सर अब बात में कुछ जजमेंट हमको करेक्शन करना बहुत जरूरी है. I am in the midst of some
नहीं
writing some judgment.
मुझे फर्स्ट हाफ में जब छुट्टी देते हैं इसका मतलब है